Good afternoon, participants. Please state your team code. Participants, would you like to have your pre-consultation session? Mm.
Greetings, judges. Welcome to the final rounds of 25th Kerala Law Academy Client Consulting Competition 2025. This is Team G. They opt not to have pre-consultation in this session. With the judges' kind permission, shall we start the session? Audience may please note to switch off their phones and please remain seated silent. This is session 2, Chamber 1, Team G. Session starts.
Good afternoon. It's a really pleasure to meet you.
Good afternoon. It's a pleasure. Please have a seat.
Thank you.
Are you comfortable?
Yes.
Okay. I am G1. I'm the senior associate of ABZ Legal.
Okay.
It's a pleasure to meet you here. And before we start with the session, I would like to inform you that at any stage of this session, if you feel a little bit uncomfortable, please let us know. And there will be several questions asked to you just so that we understand what the exact issue is and we can help in the best possible way. So, if at any point that question also makes you uncomfortable, you can choose to not answer it and tell us that
Sure.
you won't be able to answer it. Okay.
So, good afternoon. I'm G2 from ABZ Legal. And in order to elicit confidence in our firm, I would like to explain exactly our background. So, for 2 decades, our firm has been standing.
Okay.
For the past 1 decade, me and my co counsel G1
Mhm.
have been practicing. And our firm has expertise in contract, tort, and family law.
Okay.
So, we'll be providing you with tissue papers and
Thank you.
water. And if there's anything else you need, if you need any clarification in the questions we ask later, so please. Okay.
Also, before we start with the session, could you please tell us a little about you and how do you want to be addressed during the session?
My name is Srijit. So what are the details that you want to know?
We just wanted to know if you will be okay with being addressed as Srijit.
Yeah, sure.
Yeah. Okay. So during the session, you'll be seeing us referring to some notes. Those are the preliminary summary made by our legal research team beforehand, so that we can understand your session in a better way during the entire process. Also, you'll be seeing us making some notes. Those are for our internal reference, and we ensure that these notes will be stored securely and has complete privacy. Also, if we have to take this to out, if we have to tell somebody outside this firm about this case, we'll take a written permission from you, and only then we'll take that. So yeah, you can be really assured about your privacy. The only exception to this is, as required by law, if there is something that indicates a criminal imminent act, then we'll have to inform the concerned authorities,
sure.
which won't be the case in this, I
Yes.
hope.
Yes.
So the knowledge element is very important, and our firm firmly believes in transparency. So if you are aware of how this consultation is going to go, it will be easier for you. So initially, we start with introduction of us and our firm, moving on to your introduction and what
Okay.
you'd be like to refer to as, and then we will try to move on to what brought you here. So feel free to disclose that, and we will be asking questions to understand your situation better.
Sure.
If you feel that the questions we ask are unclear, please ask us to explain it to you.
Sure.
Yes, and your comfort is our priority. Anytime
Thank
you
you.
feel uncomfortable,
Good to hear that.
thank you. Let us know.
So how are you feeling? Like, how are you being? How have you
Yeah, I'm good.
been? Okay. Let's start with it. So, what brought you here today?
Yeah, I said that I'm feeling good, right? But little bit nervous though,
Okay.
as there is some legal issue that I am facing, I mean, really stressed in that legal problem. That's why
Right.
I'm here, and that brought me here.
Yeah.
So, can I talk openly, right?
Yeah.
My wife's name is Bindu, and she died last year. Actually, the problem is starting from that self. So now I come to know that the wife's sister is restraining me from entering into my wife's property. Actually, she is restraining me from entering into my own wife's property.
Okay.
She is retaining it. Okay,
All right.
that's the base of the issue.
Okay.
So now she is saying that the properties belongs to her.
All right.
However, I just married to her sister. She is saying that I am now entitled to get the family property. In fact, after the demise of father-in-law, my wife had brought all the shares of my the property, all the shares of the property of my from my wife's sister.
Okay.
Actually, my wife is holding the entire shares.
Right.
Okay. And also I came to know that she has filed a injunction suit in the court, restraining me from entering the property and also alienating the property.
All
Actually,
right.
my plan was to give the entire property to an orphanage as a gift. So these legal battle were restraining me from doing so. So I know to what should I can do against it and how can I tackle this situation.
Right.
Yes.
You mentioned that second, your father-in-law has he recently there was a demise in your family. The father-in-law died.
No, father-in-law were died many years back.
Okay, and the mother-in-law, is she still here?
No, she's also died.
Okay.
Just before we continue with the questions, I
Okay.
would just like to summarize what you have said so that we are ensured that there is no point that has been missed. So your wife died a year ago, which we are heartfelt conclusion for that. And your sister has been claiming the property, and this is a family property, and the entire share actually belongs to the wife, and you want to gift it to some orphanage.
Yes.
Right. Okay. So, starting with the first question, is this property a self acquired? So, you said that it was given by her father, your father in law. So, is this a gift or it was a property that she inherited from the family?
No, the father is gifted the property to my sister. I mean, father, wife's sister, and to my wife.
Okay. So, is if it is gifted property, so is there a gift deed?
Yes.
Okay. Right. Moving ahead. How is your relation with your sister-in-law, the wife's sister?
During her period, it was quite good.
Okay.
Not any issues were there between my sister and my wife. Between my wife.
Even after her demise, we want to know what happened after her demise.
After her demise, actually, she just get away from me, and there is no contact in between us.
Okay.
I don't know why she do like this to me. Actually, I'm unaware of the facts.
You mentioned that your sister-in-law has been living in that property.
No. It's a commercial plot.
It's a commercial plot.
Yes.
And it's under possession for the past how many years?
Under the possession of myself.
Okay.
Yes.
So your name is mentioned there.
Yes. For that
Okay.
property, right?
Yes.
So I didn't get your question clearly. That's why I'm asking.
So I'll make that question clear for you.
Okay.
We are asking under whose possession the property is, meaning that
Possession is me, mine.
with you.
With mine.
She has just filed a suit.
Yes.
Right.
I claiming that the property belongs to her after demise of my wife.
Right. Could you explain how is your marital relationship with your wife?
It was really good.
It
There is no issues between us.
right. Do you have any children?
No.
No. Okay. So, from which religion do you belong?
Hindu religion.
Hindu. Okay. Uh, so did you try to have a conversation with your wife's sister after the suit was filed?
Actually, I tried to call her over the phone, and I
Yeah.
also sent a mediator for the same because I am staying
Okay.
far away from the place where she is staying here.
Okay.
So, but she all rejected it and she didn't take my call. So I'm not able to connect her.
So the mediator you're talking about, is it a professional
No,
mediator?
it's my friend.
Okay. Okay. Is your father-in-law and mother-in-law alive?
No, that I already told you.
Mother-in-law is also passed away?
Yes,
Right. Okay.
that's years ago.
Years ago,
Yes.
right. Uh,
So you said that she rejected mediation. She
Yes.
hasn't talked to you about this property, or has she had to talk about this property with you? Did she mention before your wife's demise that she has a claim over this property for any reason?
No, no.
So
There
this
is
was
no
abrupt.
talk in between us regarding this property or any other financial matters.
Okay. And how's your sister-in-law doing financially?
Sister-in-law,
Yeah, the one who's claiming the property.
she's having some job.
She's having job. She's
Yeah.
financially well.
Yes.
Okay.
what are your financial conditions? Like,
I'm a pensioner.
okay.
I'm retired from BSNL.
Okay. So what are you looking for? Like, do you want the entire claim of the property, or do you want this matter to be resolved as soon as possible?
Obviously, I need to resolve the matter as soon as possible because I do have all the documents with me and I am entitled to the particular property.
Right.
And I am not sure, I mean, I am not aware that why she do this to me
Right.
because there is no objections. I mean, there is no points that she is claiming the said property. Actually, the entire property is within myself and I am claiming it too.
So you mentioned that the property is with you.
Yes.
You have all the claims.
Yes.
So for us to make a clear decision, we need to know all the documents that you have that support your claim. If you could just tell us about it in
Uh,
detail.
Yeah, I do have the sale deed during at that time. I mean, when the time of the I bought the property, and also I am paying the tax for the said land.
You said that it was a gift deed, which was no, you earlier mentioned it.
The gift deed is from the father to my wife.
Right.
That equal share when 50% of the land is going to my wife and the other 50% is to my wife's sister. Okay,
Okay.
and my wife just brought the another 50 share of the land from my sisters after giving the nominal amount during that time.
Okay.
So the entire property is with me with my wife's name.
And your wife has mentioned you as a beneficiary directly. Okay. And she hasn't mentioned your sister anywhere
No,
for a claim
not
to
at
the
all.
property.
Because she bought the
For this-
property from my sister when she bought the shares from my sister, I mean wife's sister.
So she has gone for injunction and she is taking very hardcore legal action.
Yes, that's why I'm a little bit confused at why she's doing.
So we know that you went for mediation. That means you have some knowledge of law. How do you think what legal stance is she using against you to try to grab that property? If you can tell us.
Actually, that I don't know. That's why I'm here in front of you to get the legal remedy for the said action.
Yeah, we will obviously do that, but we need all information possible, right?
No,
Okay.
I just do some basic information from the Google or somewhere like that. So it is better. My friend suggested your firm to that better. I will just go to a legal remedies for
See,
it.
we ensure you that we'll help you at the best possible solution we have. For that, we'll have to ask all the questions that are arising in mind right now, so
Okay.
that we get a clarity about what is happening. So,
Exactly that the clarity which I needs to.
yeah,
And I know that on what circumstances my wife's sister is just going to the court
Yeah.
and file the injunction suit against me.
right.
That sounds also I am just a bit confused.
Yeah, we understand that.
Okay.
Along with that, I just had to make one clarity that your wife got a property, and she also brought the share that this belonged to the sister.
Mm,
So
yes.
the sister is claiming that property which was brought, or the entire property in totality.
The entire property. She is
In
saying that
totality.
entire properties belongs to her after the demise of my wife.
Okay.
How were your relations with your sister-in-law before all of this happened?
It's really good. There is no what show us any kind of allegations or somewhat like that. It's really good.
Are you willing to share some part of the property in order to maintain the relation, or you want the entire property back?
No. During this stage, I am not willing to do the remedy that you have said.
Okay.
Could this problem have been arise due to any ego clashes or any other external factor other than the demand for the property?
I don't think so. She started the legal actions after knowing that I am going to give the entire property to an orphanage.
Okay. So she
Because
has
whether
a
she thinks
problem
that
with,
the property will get to her after my death. So maybe she is dreaming of that.
so
So
she
when she
has a
knows to come,
problem with,
pardon?
so she has a problem with you giving the property to your wife. Sorry, to the orphanage.
Yes.
Yes.
I think so.
We need to ascertain a thing that you said that she started legal action after she got to know that you're trying to give the property away to an orphanage.
Yes.
Did she try to force you, coerce you, try to threaten you in any way?
No, no, no.
No
She didn't
threatening.
even make a call to her asking about the matter.
Yes.
That's I am very much sad. So
Okay.
she can make a call, like just actually she can make a call and ask that why you are giving this property or something like that. But she didn't do anything like that, and she directly approached the court and filed the injunction suit.
Hmm.
Did you see this injunction suit?
Yes.
Yeah. So when is the hearing date or the next session scheduled? If you
So
could
she is
tell.
scheduled in 2026.
2000. So we have a lot of time.
Yes.
Okay. I is there anything else that you want to add? Any information that you're
So all the
missing?
basic details I will already told you that, and I think that the property is entitled to me itself, and there is no
Right.
other way that whether she can get entitled to the said property.
Right.
And I need to know that is there
Yeah,
any
we'll get into
circumstances?
that. We just wanted to know if you want to share any other information with us. As far as we have understood this problem, if the co-counsel does not have any other question.
Should I explain the finances to you before, after she gives you the legal remedy?
Yeah.
Okay. So you said that you're financially stable.
Yes.
Okay. So our firm has we have a secretary who would be sending you an email in which there's going to be a retainer agreement
Okay.
and there's going to be a financial agreement.
Okay.
And you said that you are not preferring mediation a lot. You're tilting towards court, right?
No, I'm not saying like that. I prefer mediation or I am ready to get mediate, but I think that she will not come for that.
Yes. So there is a
But there is lot of chance for her to contact me, right?
Yes.
Yeah, so she didn't use it. So
Okay.
still I'm ready to appear for the mediation.
That's great if you're preferring mediation for a family matter. It's something that we at ABZ recommend as well.
Okay.
So, what will be doing is that Andrew will be sharing an email with you with a retainer agreement, a financial agreement.
Okay.
Retainer agreement, what is the concept is that we will ask for some lump sum amount, say 30,000,
Mhm.
and every single legal process when we have to withdraw some money, we will be withdrawing simultaneously. We value transparency. So if you are going to withdraw a huge amount, we will initiate a conversation with you, let you know.
Mhm.
And that's about it. If there's anything else you'd like to add or to your situation so that she can conclude.
No.
Okay.
So, from as far as we could understand, we have not reached at a position where we can give a cut short legal guidance to you. For that,
Okay.
we'll have to review different kind of documents to reach at that conclusion, and for that, we'll have to keep a next session.
Okay.
But before that, we'll need some documents. So, we'll schedule the session only after we verify the documents. These this will be the list will be shared through Andrew, but I'll just let you know what all will be there. As you said, there is a sales deed. The sales deed is
It is
needed.
with me.
The
Yes.
gift deed is needed, and the
Gift deed means the
Uh,
father has got.
right,
Okay.
right. Also, the property. Sorry. The tax receipts of the property.
Okay.
Also, the payment receipt of the sales deed. Also, your wife's death certificate. All these things are needed. Do not worry about it because we'll share a mail where we'll list all these documents with a financial agreement statement so that you can go through it one more time and make a sound decision.
Okay, sure.
Okay. Now I'll tell you the legal position from the picture you have given to us right now. As you are Hindu and your wife is also Hindu, I'm assuming that. Is that correct?
Yes.
Yeah. You are being governed by Hindu Marriage Act. So under Hindu Succession Act, if a on wife's demise, I'll not tell you the sections and all because I don't want you to get complicated with legal terminology. It's our duty.
Okay.
Basically, if a female dies, so the property initially goes to the husband and children. If it's a self-acquired property or a property that does not belong in the ancestral root or has not been a part of partition. So in this case, it has been given as gift deed, but once we verify the gift deed, then only this will be the final solution. We're just giving a temporary solution right now. once the gift deed is verified, if the clauses are correct, if it is valid, then you have the right over the property in that case.
Okay.
As the children do not you do not have any children, so you have the complete right of the over the property. Like you said, there has been a suit of injection that is already filed.
Yes.
So what we have to do immediately is to write a written statement, and it's simply a reply to the suit, which has to be given to the
Primary concern is me to revoke the injection as soon as possible.
yeah, right. That we'll be doing that. I really appreciate the fact that you have done a research and you have come here. That's
Because I'm that much stressed in this problem.
yeah, we understand that,
Yes.
and that shows how concerned you are about that issue, and you as a client in ABC are at most priority. So before getting into the court drama, I and my counsel would suggest that let's try mediation to a neutral third party,
Okay.
because the main issue is we have your wife's sister involved. It's a family member. She must be also going through a tough time like you, as she lost her. Yeah,
If she's going into a tough situation, she will not do this to me.
yeah,
Right.
right.
So then she was done this to me that she is not going through that tough situation.
Right.
I'm the only one who cares about that.
Right.
And I am the loser, and I'm become alone in this world. And I lost my my wife.
I understand your situation, but the reason could be just a small ego clash or some misunderstanding. We do not know. We have not heard her side. So let's hear her once, and then we can take. If she is not ready to settle that thing amicably, then we can move forward to the court. It will always be a final resort, and we will try to get you the justice.
Regarding mediation, when you're talking about it, you said that your relation with your sister-in-law was good initially.
Yes.
Right.
Before the wife demise.
Yeah, so we would like to go for mediation initially to find what state she is in. I'm not sure if we cannot predict someone's behavior, right?
Yes.
So if she's being that aloof, I think we should get a good stance, because when you go to court, it takes a lot of time. So if you can resolve it amicably, it's good. And you said that you were alone and everything, so we are here for you legally, and we will be
So will it
contacting.
take much time to revoke the injection?
You s-
Or you're saying about the time which is needed to resolve this entire issue when we approach the court?
If we approach the court, it will take time because
So can you tell that exact time? So how many months or years like that?
probably
According to your knowledge and your experience that you can say, right?
yeah, probably around 6 to 1 year, 6 months to 1 year
Mhm.
is the time we are
Just
assuming
revoke
right
this-
now, but we cannot give you a proper answer until and unless we actually uh,
That
give
I
you.
can understand. I am asking that how many time will it take to revoke this injection suit again, which is action
Right.
against me?
So we'll have to file a reply to the suit. Then there is a lot of process which we'll discuss later because we do not have the documents right now. We'll have to verify.
All the documents in the
Yeah,
next session.
yeah. The next session we'll have a proper answer to this because we don't know what the exact contention that the opposite party has made to us. So after understanding that only we can give you a proper answer. That's why I am
So you said that
refraining
you
from
need to see the documents which I hold.
Yeah.
So apart from mine, I had a doubt in that.
Yeah.
So what's the situation that why this injection suit is just allowed without seeing the documents? So there is any what the perspective that the court just allowed this injection?
suit must have not been allowed. There was a suit filed and you have been
And also, is there any possibility that the place, I mean, the land will go to my wife's sister?
No, there is no possibility
Sure.
until and unless it is a ancestor property that has been given to your wife through your parents.
I
Through
think it's not
partition
an ancestor
or-
property. It's
yeah.
just given.
Yeah. Then there is no claim that the sister can make. So you
Do
can
it, right?
relax.
Okay.
Yeah, you can
So already
relax.
the 50% share is with my wife itself.
Right.
And another 50% share is bought by my wife by giving the nominal amount during that time.
Right.
So I know that, but so the injection is allowed. That's why I'm get tensed.
Yeah, I understand.
So
your
there is some
concern.
provisions, right?
Yeah, there is a lot of provisions to help you out here.
Okay.
I do not want to name the provision, but if you want me to tell
No,
you,
I'm not telling about the provisions.
yeah.
That's a
I
supporting.
told you the actual law that if it's a
No,
self.
I'm not saying about that. I must have to know that why this injection must have to be allowed to the against me.
So the injunction must has not been allowed. The suit of injunction must have been filed, and you must have been informed. So we are not sure what actually it is. So that's why we asked that documents is absolutely needed. And then only.
Maybe I'm living outside the place. That's why the serving notice where didn't receive my way.
Okay.
Maybe that's why the reason. I think.
Yeah, that could be a reason.
She gives that. I mean, by home address or something like that.
Yeah. Okay. You have
And
not.
that's why I'm very much worried that I'm not getting the information up to date. I'm just getting the information by delayed.
Okay. So what we'll do is we'll we'll send a legal notice to her.
Okay.
Initially,
We
that's the
should have to
first.
file as soon as possible.
Yeah, the next hearing of injunction, as far as you said, is in 2026.
January 16.
So we have a lot of time for that.
Okay.
So let's first try to settle this amicably. So let's by next month let's have a meeting where we can discuss. We can bring them to the table and discuss about the amicable solution if that is possible. And once that is done, if we think that she's not ready to accept it, then we'll move forward with the court thing. But we'll be filing a written statement as an answer to the uh, summon that you sorry not summon the suit you have received, and also that will be also our priority along with the mediation thing. Later, see if we'll also file a declaration suit for the ownership of the property. That will be one of the steps that will be taken by us. And the other one would be that if she is trying to transfer the property without our knowledge, or if she tries to take the possession, because we are not living there, right?
Yes.
So if she tries to take a possession, we'll also file an injunction. A temporary injunction we'll file, so that until and unless this case gets resolved, there is no possession over the property by your sister.
Okay.
Or anybody other than your
So
sister.
according to you, I can go with peace of mind, right?
Yeah, of course.
I have no worries on that particular land, and the land will just get back to me.
Yeah. To give a confirmation on this, we'll need the documents.
Sure.
But 95% we can give you the assurity, not even 95, but 99% assurity we are giving you.
Very good to hear that.
You can go back, relax.
Thank you.
So regarding the documents, please send it to us as soon as possible, because in the next session we'll be requiring to research and we'll be required to read the documents. So we have
Okay.
given you hope, but from our side as advocates, we're supposed to do our research.
Okay.
Okay. And if there's any doubt so far,
No, I will submit the offline copies by direct under next sitting. So, do you have any card or something like that? I can contact you. So I can send it to mail
one
as scanned
second.
copies of the said documents.
This is our card,
Okay.
and you can see our email and phone number in
I
here.
think sir, this is the mail ID.
Yes.
Okay.
And the phone number is below.
Okay. Thank you.
So you can call our secretary, and our
Okay.
emails and everything, we reply quickly.
Okay.
So you should be assured, you should rest assured.
By today evening, you'll be sent a mail through Andrew listing all the documents that you need. You need to submit, and try to submit that as soon as possible.
Okay.
And this
I
was
will done it tonight itself.
sorry.
I will done it tonight itself.
Okay. Yeah. So this was indeed a fruitful session. I'm looking forward to the next session so that we can discuss the actual possibility once we have reviewed all the documents and see whatever the evidences are available to support our case. And as you have agreed to have one mediation session, we'll move forward with that. And we'll send a notice. That's the first thing we are going to do. And we'll intimate every process that we take beforehand. If we are sending a notice today, you'll be informed yesterday about the thing, so that there is complete transparency and you feel really assured and relaxed. So
I hope that next session will come soon.
Yes, definitely. So this was a very fruitful session. You were very forthcoming with the details, and we'll get back to you. If there's any
Yes.
further doubt, we are open to answering your questions on email as well.
Yeah, sure.
Okay. It was our pleasure.
Thank you so much for trusting us. We'll drop you till there.
So, Jeevan, what is your thought about this?
It was indeed a insightful session. The
Yes.
party is really worried. The client is really worried about the property, but he is doing it for a good deed. He is going to give that to orphanage. That actually shows how pure his heart is, how he want to help people.
And he has this prerequisite knowledge of law,
Yeah.
which was rare, but at the same time
Right.
very, very nice. And regarding the sister's behavior, I think we can push for mediation if the client allows, because her behavior has been hot and cold. So there's a possibility.
Yeah, there is a possibility that it could be because of some ego clashes or something that he is hiding from us at
Yes.
this point of time, or maybe something that he also does not know.
Yes, because he asked about injunction, that how could she claim against him. So if we don't go through the documents, even we will not be able to find it.
Right.
Yes. And regarding the legal aspects, I think law is in our favor. All the
Yeah.
sections are in our favor.
For that, we'll have to verify the gift deed again.
Yes.
He's saying there is a gift deed, but I saw he's a little confused whether it's gift deed or something else.
Yes.
He was not very sure. So for that, we'll have to actually verify, and we cannot accept him to know everything properly.
There was a little confusion regarding the facts, which is why I felt like until and unless we don't have the documents, we can't really have a concurrent decision.
Right.
Which is why Andrew would be asking for the documents soon enough.
Yeah.
And injunction has been filed for 2026. Before that, we could push for mediation.
So we can start by preparing a legal notice, putting a clause of mediation in it,
Yes.
and we can keep that mediation session as soon as possible once the document is reviewed, and uh, we have our next schedule with him. Once we are done with the next schedule, we'll give him a clearer picture, and once that is done, within 2 or 3 weeks, we can schedule a mediation session.
We also need to ascertain the death certificate.
Yeah. Along with that, I missed one thing. The suit. The suit. He said that he received an injunction order. So we need to see what is it, an injunction order or a suit of injunction that has been filed and a letter has been received by him.
Yes.
There is no clarity in it. I think he must be not understanding the difference. He may-
Yes. So for that, we need to see the documents definitely, and we'll meet tomorrow at 5.
Yeah, by then I'll draft the legal notice, and I'll ask the research team to do all the needful and research about the case laws and every aspect
Yes.
that is needed.
And I will ask Andrew to send the financial documents.
Right. Okay. So I think this was a good discussion.
Indeed, and it was fruitful as well.
Yeah. So then we'll meet tomorrow.
Sure.
Thank you. Bye.
Thank you. Bye.
Actually, his sister-in-law, the wife's sister,
He has come to you.
because there is a claim of
No. What is it that worries him now?
that
Just know what is
the property that he has will be.
He has already been saddled with an injunction order, isn't it?
Yeah.
Yeah. So therefore, what does he want from you?
He wants to remove the injunction order
What do you do?
immediately.
When a person comes with an injunction order, what do you do?
We'll have to file a reply as far as I understand, and to cancel out the injunction, we'll have to go to the civil court.
What are the materials for getting an injunction?
I'm not
Is it a
fully.
temporary injunction or is it a permanent injunction?
We'll have to look into the documents that
How
we'll
could,
be
how could
receiving.
it be a permanent injunction if the other side has not been heard?
That is for sure that it's not a permanent injunction, but
Now, what is the injunction that is saddled against him? It's an ex parte order of injunction.
yeah, sir. But for that,
What is the law regarding an ex parte order of injunction?
so to understand that what injunction, it It is a temporary injunction for sure.
What is the law regarding that? When a person is saddled with, when a person is fastened with an ex parte interim order of injunction, what is the law? What is the procedural law?
Not fully aware about that.
What is the procedural law? See, you are being saddled, you are being fastened with an ex parte interim order of injunction.
Right.
What is the procedural law? Is there any provision for that?
Yeah, there is a
What is the
provision.
provision?
Recovery of possession. No,
Recovery of possession.
injunction would be under section.
Section.
I'm not really aware of about the section, so I'm so sorry for that.
Is there a provision called as section 94, order 39, rule 1, order 39, rule 2?
Yeah,
And does order 39 gives you any remedy?
yeah, that actually talks about the temporary and permanent.
Is there any time period fixed for disposing an application for an interim order of injunction? And is there any provision which says that if an ex parte order of injunction is granted, then is there any time period for which the court should dispose of that matter?
As far as my understanding is, it's 30 days.
Ah, you know that. So what do you
Yeah.
do then?
Uh,
Okay. You spoke about a legal notice.
Yeah.
What is the legal notice you are contemplating when a person is already saddled with an injunction order?
we
from the court?
actually thought of adding a mediation clause. That is our utmost priority because the person involved there is a sister-in-law, so they have a family connection. They are under ego and some sort of a personal grudges involved. So maybe by making them
No,
sit in
come
a
to the legal point. These are all sentimental issues.
But sir,
It's all
it's
filial
family,
dialogue.
so
Come to the legal field. You are an advocate. Okay, leave that. Now you said that it is a suit of declaration. Maybe.
right.
What is it that you are going to do? You are going to file a suit for declaration.
So if the injunction get cancelled,
No,
then
you said you are going to file a suit for
in
declaration.
later stage, I said in later stage we can file that once the injunction is revoked.
Suppose there is a suit of declaration coupled with a consequent relief of injunction. Okay.
Right.
Okay. Then how do you put up your rights?
Sorry.
Should you file it by a separate suit?
Yeah, we can file a separate.
Have you heard of something called as counterclaim?
Yeah.
How do you do that? What is that? A comes with a suit for declaration. He also
Right.
comes with a consequent relief.
Right.
But B, your client, has got substantial rights. What do you
Right.
do? You'll file a separate suit.
No, we filed counterclaim for that.
Then
And
why do you
we-
go for a declaration then? Okay.
No, what I suggested was if the injunction get revoked and in a later stage we can file a declaration for ownership, absolute ownership,
Mm.
so that there is no further problems in this.
Who has possession
matter.
here?
The possession is with him only.
With
The
your
client itself.
client.
Yeah.
Who has title here?
Sorry.
Who has title here?
The client.
With your client. How do you know that your client has title?
He told that he brought the 50% of share.
What are the documents regarding that?
That we asked
Okay.
for the title.
Where is the document to show that he has got possession?
We asked for those
And if the
documents.
possession and the title is with your client, what do you do?
Sorry.
If
Could you
the,
please-
if the title and the possession is with your client,
Right.
then what do you do?
Firstly, we'll revoke the injunction. That is
On what ground? What ground? What sure and certain ground? Sure and certain ground. 100% sure and certain ground. What are the grounds for injunction order? 3 grounds.
not aware.
Prima facie case, irreparable remedy, balance of convenience. Where does the balance of convenience lie? Where does irreparable remedy injury lie? Where does the prima facie case exist? If the document of title is with you, if the tax receipt possession is also with you, then does he have a prima facie case?
No.
How do you fight it?
But we'll have to revoke the injunction.
How do you fight it? Is it by filing a written statement or filing something else?
We'll have to file a written statement first.
That is in the suit.
Yeah.
When you have this, when you have these two things, and the other party does not have a prima facie case, then how do you fight it? Is it by filing a written statement?
But that I guess is
Is it by filing a written statement?
yeah. Yes.
Okay. My friends will ask you. Okay.
Have you heard of counter affidavit in your see what is a temporary injunction that has been used? He claims that there is a temporary injunction.
Right.
Okay. So when there is a temporary injunction that is ordered in a case, so it is ordered on an interlocutory application, right?
Right.
So what do you file when there is an interlocutory application pending where there is an order that is passed, a temporary injunction? Then what do you file? You file a not a written statement, you file a counter affidavit in that. And to get, it's not to revoke the injunction. The word used is vacate. So you need to get it vacated.
Apologies for the mistake.
That's okay.
No apology.
No. Apologies. It's okay. We're just trying to, make you understand. The other thing is when there is already a case between the parties,
Right.
and then a couple of times you mentioned that we'll issue a notice to them.
Right.
There's no question. She's already in court. She's already, no, I don't think you need to justify that any further. She's already in court and you've been called upon to answer because there is an injunction order and you've been served with something.
Right.
So your job is to attend court and explain and get the thing vacated. In between, there is no point that you file a notice or issue a notice to her. That's totally out of context.
The why we did that is as a firm which believes in family.
Whatever your firm may believe, but that is totally unwarranted. So there's no point in, again further justifying that stand that, okay, we'll issue a notice to her. She's already in court. So there's no point in, and you have been asked to answer. Some allegations are there. That is there. Okay. So there's no room for a further notice to that person. That is one thing.
Okay.
That is one thing. The other, as my brother said now, when somebody has come, there is an injunction against him. There's no question of filing a counter suit. I was just thinking that you were saying that, okay, we file a suit for declaration, which is like unheard of.
That I said it for later stage, not the initial
Why
stage.
are you are trying to multiply litigation? Are you trying to promote your firm? ANZ.
Clear reason.
Absolutely, that's not honest. That's not honest. That's against your Advocates Act and the Bar Council rules.
So actually, that will actually avoid him, save him from future.
Absolutely not. There is already the matter is seized by the court. You can tell the court this is it. He has the documents and he's in the one basic question you have not asked at the time of this injunction. Automatically, was there a commission application? Has somebody visited and checked with whom the possession lies? He claims that it is with him. Did you ask him where he belongs to and where the other property is? He says he is not residing there.
Right.
Where is this man from? That's the first thing that you should ask. Where are you coming from? What is your address? Where do you live? And where is this disputed property? How far from your place? If he is in Bombay or Chennai, this property is in Trivandrum. So how do you say that he is in possession? Maybe he just has some sale deed or something. So these are questions, basic questions that you need to elicit information from the. I'm not blaming you, just trying to, just telling you. So these are things that you need to elicit from the person, right?
So we're really sorry and
No apologies. It's just a learning, just an exchange of ideas.
yes.
I'm just
So
telling you this.
we asked about the possession, but we did not get into the details.
No. The first thing you should have asked is where do you live?
Yes.
Where are you
yes,
coming from?
Yes.
Right.
So I think somewhere it's mentioned he's in Chennai or some other from the records I see. So which means he's not in this place at all.
We did understand that because he mentioned it while speaking that he doesn't live where the property
Yeah,
is.
that's right. But how far? Even if
Yes.
he doesn't live there, he can manage it on a daily basis if he lives about a kilometer away.
Yes.
So that depends on where he belongs to. One basic thing. So logically, these are the things that you need to ask him. One. Secondly, he says that he got an injunction order.
Yes.
How was it served on him? When was it served on him? These are the pertinent questions. And if it was served on him, was it served while he was on the property? Or what address was shown in it? The court
did
has
mention-
issued something.
Yes.
That order has been served on him.
Yes.
So is it served on his Chennai address or wherever he is or where? And then simultaneously, ordinarily, you are people with 10 years standing. So you know when an injunction order is passed, ordinarily there should be a commission application and a commissioner's visit, ordinarily in such cases. whether something like that happened in this case or not. That is also very important, right?
So we basically tried to give all possible remedies, but we did not sequence it properly. So here
I
we
wouldn't say
fall
you gave
short.
all possible remedies. You
Yes.
gave all wrong remedies, I would say.
Trying to put him in a word. Why you thought of that?
Yes, yes.
That was wonderful.
We were trying to push for mediation a lot, but yes.
So when you found that the basic question was how to get this order of injunction vacated,
Yes.
then did you go through the provisions under Order 39, which deals with all these provisions relating to injunction, how to vacate it, what are the procedure formalities to be complied by both sides, especially the plaintiff after obtaining an order of injunction, what should he do?
No, sir. We did not. We'll be honest.
Should have been.
Yes.
Then he has come just with some basic information like there was an order of injunction passed against him. He doesn't even have. He doesn't even know when, etc.
We did ask, sir. We asked when the injunction suit is going to happen. He said it's going to happen in 2026.
2026 is, sorry to
Yeah.
interrupt. One more thing. Did you ask from which court this has come? Is it from the Municipal Court or from the sub court?
Yes.
Basic pecuniary jurisdiction. So now if you had asked that question, you would have got an idea whether it's a simple injunction suit or something else, depending on which court is seized of the matter. That has never struck you. You never asked, right? That would have been very. You could have just asked from which court this is. That
Yes.
would have answered several of your questions.
Yes. It could have also helped us where it is served as well. You said that if he's somewhere else, then we would have got to know about it.
Apparently, the court has passed an ad interim injunction.
Yes.
That is an injunction passed even without issuing notice to the other side. That's an ad interim injunction.
Okay.
In
Yes.
such cases, when the court passes such an order, the plaintiff is bound to forward the copy of all the documents he is relying on by a registered post on the very same day and produce 3A. And the very same day, he is bound to submit the proof of that, including the postal receipt to the court. So in this case, injunction will automatically get vacated. That itself is one of the grounds to see that the injunction is vacated. You do not even go into the merits at that stage. Then the court will hear the injunction leisurely later and then decide after hearing both sides whether the injunction should be granted or not. So here he has just come without all these things, and according to him, it was passed several months back. How he missed it? Supposing you were aware of that provision, you could have put that. The moment you
Yes.
came to know that he is now pestered with an injunction order, he wants to somehow get it vacated. The first thing that should have come into the mind of the lawyer is whether the man is served with the papers, the affidavit, the documents he is relying on, etc. Along with this. If not, then why that question was not
Then
put
it
to
would
him?
automatically have gotten vacated. That would have helped us a lot.
Because that is a mandatory action, the steps the plaintiff has to take. So supposing you were aware of it, you had gone through those provisions, this question could have been that one question which ought to have been put to him.
So there were
That-
many great questions we missed. Many great questions.
That's true. But no, we are only trying to tell you what are in such cases, what are the relevant questions that could arise when a
Yes.
client approaches you saying that an injunction order has been passed. And in the injunction cases, one of the most important aspect, what is that? Whether it is title or possession, that is the utmost thing the court looks into. Only the question of possession mainly. So therefore, the plaintiff has to first establish his possession. Notwithstanding that he has got title over the property, still it is for him to establish any proof to show that he is in possession. That's why my friend brother was saying that whether you would ask him whether any commission had come to the property, how did you come to know about all these things? Where are you? Whether you are an absentee landlord, whether you are in the property, you are in the property, or you are staying elsewhere. All these were some of the very pertinent questions which the lawyer has to put. elicit the actual facts.
Let me tell you one thing. Other thing was all these things.
Thank God. Thank God.
Yeah. On to the question then. According to your assessment, from what you could gather, whether he stands in the position of a co-owner or a full owner of the
But
property.
that we asked. We asked if the possession was complete, if it was he was under the possession, and he said that
No,
he.
possession is different from the question I have put.
Okay.
Co-owner of the property or a full owner.
Okay.
Possession is this immediate possession, physical. Two different things. This is
Yes.
co-ownership is a question on the title.
Yes.
Supposing he had only a fractional share which he got from his wife, then he is only a co-owner. Supposing he claims that by virtue of the document he becomes the absolute full owner, then he becomes the entire title holder over the property.
Yes.
Yeah.
So if he's a co-owner, if he's a co-owner, what is the position?
What is the position when in relation to an injunction against another co-owner?
The sister is not the co-owner.
No, can a co-owner maintain an action for injunction against another co-owner? Why? Cannot be done at all.
Property is
Cannot be done at all.
But
property is individually enjoyed as the
No. They ask, no, answer it legally. That I can also answer it legally. See, can a co-owner maintain an action for injunction against another co-owner?
no,
As far as it's no, until and unless there is no enjoyment of the property.
No. That is not the legal way to answer the question. It's a principle called as ouster.
oust.
So can you please explain it so we don't make this mistake again?
If a co-owner has to maintain an action for injury, you specifically come up with a pleading of ouster.
Ouster.
Oust.
Okay.
So the law presumes that the co-owner is also in joint.
Yes. Even if
That's the logic. See, when there are two people in possession, so can one say that, I need an injunction against him because both jointly own it and possess it. So that is the thing. So therefore, a co-owner cannot maintain a suit for injunction against the other co-owner. Under law, it is an impermissible. That is
The
what.
other thing answer.
Yeah.
that's right.
One other thing I wanted to ask you.
You are in trouble.
This client has been, ranting away saying that,
Yeah.
I don't know how this injunction came. Is it not yet? Because it means, there's a question. There's a doubt on the system. How can the court pass an injunction order? You should have explained to him, see, your sister-in-law would have, pleaded something there, which you have not been heard. So based on that pleading, an order has been issued. So that can be vacated if the court comes to know that no, this is the real fact. Now this is when the client is asking, you are also sitting. Oh, how did that happen? You are supposed to explain to him and defend the court in having passed an ex parte order. It's an ex parte order, and that is based on what was pleaded there. So you are bound to defend the court and the system. As a lawyer, don't you think that's your duty? Rather than sitting and saying, oh, you got an injunction against you. Oh, we don't know how it happened. That's not the way.
Mediation.
All right.
That's
Why to the other thing? Why to the other thing?
Anyway.
let them not lose their hope.
Yeah, very frank. Okay, very frankly. Yes.
Anyway, you did well. You did well.
Okay, all the best.
Thank you.
We'll put up the mark.
I think.
അല്ലേ?
ഇത് എങ്ങനെയാ ചെയ്യണമെന്നുള്ളത്
അതെ, അതെ.